Welcome to your deep dive on remedies for breach of contract.
I think you'll be surprised by how these concepts actually play out in court.
You sent over some interesting notes and legal cases on what happens when a promise made in a contract is broken.
Yeah.
We're calling this one the a la carte menu of legal options because we're about to break down the legal remedies available when a contract goes sour. All right, before we dive into specific remedies, let's set the scene.
Good.
What are the key things we need to consider when a contract is breached?
Well, first, it's crucial to analyze the nature of the breach.
Okay.
Was it a minor mishap or a major violation? Did the breaching party back out before even starting?
Right.
And critically, did the wronged party try to minimize their losses? These factors heavily influence what remedies are available.
It's like investigating the scene of the crime of a broken promise. And speaking of getting things back on track, let's talk about expectation damages.
Yeah.
I've heard these are seen as the ideal outcome in a breach of contract case.
That's right. Expectation damages are all about putting the non-breaching party in the position they would have been in if the contract had been perfectly performed.
So if someone promises you $1 million and they break that promise, they automatically have to pay up $1 million.
Well, it sounds simple in theory,
Right.
but it can get incredibly tricky to calculate in practice,
I see.
especially when dealing with things that aren't easily measured, things that don't have a clear dollar value.
Okay, I see what you mean. Like, how do you put a price tag on a broken promise that involves something subjective, say, the results of plastic surgery?
Exactly. Which brings us to a fascinating case you shared, Sullivan v. O'Connor. This case beautifully illustrates the complexities of expectation damages when dealing with a nose job gone wrong.
Let's unpack this. What happened in Sullivan v. O'Connor?
In this case, a professional entertainer sued her surgeon. Why? Because not one, but 3 surgeries left her nose in a worse state than before.
Oh,
The court struggled with measuring the value of a successful nose job. Ultimately, they leaned towards reliance damages instead of expectation damages.
I can see how putting a dollar amount on a perfect nose would be a legal nightmare. So tell me more about these reliance damages. Is this about undoing the harm caused by the breach?
Yes.
Like, if we can't get you to the promised land of the contract, let's at least get you back to where you started.
You've got it.
Yeah.
In Sullivan's case, this meant covering the costs of all 3 surgeries and compensating her for the worsening of her condition.
Wow.
It's a more practical approach when pinning down the perfect outcome, and its value is impossible.
That makes a lot of sense. But what about those unforeseen consequences, those domino effects that a breach can trigger?
Oh, right.
Like, in this case, maybe the botched surgery affected her ability to work, leading to lost income. How do we deal with those?
Those are addressed with what we call consequential damages.
Okay.
This type of remedy covers losses that are a direct result of the breach.
So, in Sullivan v. O'Connor, the third unnecessary surgery and the related suffering would fall under consequential damages because these were additional harms directly caused by the initial breach of contract.
That's right. The third surgery and the suffering tied to it are classic examples of consequential damages.
This is fascinating. So we've got our entree, the expectation damages.
Yes.
And now we're adding side dishes like reliance damages and consequential damages to make the non-breaching party whole again.
Right.
Are there any other items on this a la carte menu of legal remedies we should know about?
Well, there are certainly some important nuances to consider.
Okay.
For example, there are limitations to consequential damages,
Okay.
particularly when it comes to foreseeability.
I was just thinking about that. Just because something bad happens after a contract is breached, it doesn't automatically mean the breaching party is responsible?
Precisely. This is where the Hadley Doctrine comes in.
Okay.
It basically says you can't hold someone liable for damages they couldn't have foreseen.
Okay, I need an example. I'm very much a show me kind of learner. What does this look like in real life?
Okay, imagine you ordered a custom-made cake
Okay.
for your friend's surprise birthday party,
All right.
and you hired like a renowned pastry chef
Yes.
known for creating these elaborate show-stopping cakes.
I'm already anxious about what's going to happen to this cake.
Unfortunately, the bakery completely messes up the delivery,
Uh-oh.
and the cake arrives destroyed.
Oh, no. The party's ruined.
It certainly puts a damper on things.
Yeah.
Now, let's say you never told the bakery this cake was for a surprise party,
Right.
let alone a very important one.
Okay.
Can you sue them for ruining the entire event
Right?
and demand they pay for, say, a whole new party at a fancy venue?
So even though they mess up the cake, I'm not guaranteed compensation for a ruined party.
Right. The Hadley Doctrine would say in this case, probably not. The bakery couldn't have reasonably foreseen that a late cake would lead to such drastic consequences. They might be liable for the cost of the cake,
Okay.
but not the cost of your friend's dream party.
So communication is key.
Exactly.
I need to tell the bakery, like, this cake is super important. A ruined cake means a ruined party, and you'll be on the hook for everything.
Exactly. Being upfront about potential consequences helps manage expectations from the start.
Right.
This principle of foreseeability is enshrined in something called UCC Section 2715.
Okay.
It essentially says damages are limited to what was foreseeable at the time the contract was made.
That makes a lot of sense. You can't hold someone responsible for something they had absolutely no way of knowing. It seems like we're talking about being fair and reasonable on both sides.
Absolutely. And this idea of fairness comes up in another way.
Yeah.
What happens when someone backs out of a contract before they were even supposed to perform their part?
Okay.
We call this anticipatory repudiation.
Okay.
Essentially, they're saying, nope, not going to do it before even starting.
So if someone backs out of a deal early, how do we even begin to figure out damages? Do we just gaze into a crystal ball and predict what the market value would have been if they had honored their end of the bargain?
It'd be interesting to have that power.
Right?
But
Right.
luckily, it's a bit more grounded than gazing into crystal balls.
Okay.
This is where UCC Section 2723 comes in, which deals with proof of market price.
Okay.
Essentially gives us some guidelines for determining damages when a party backs out early.
Okay, so walk me through this. Let's say I order 1,000 custom-made robot action figures, a limited edition to sell at a Comic-Con, and the supplier backs out a month before the event. What happens next?
So we're talking about goods, those robot action figures.
Right.
And according to UCC Section 2723, we'd look at the market price at the time you learned about the breach.
Okay.
In your case, a month before Comic-Con.
That makes sense because that's when I could have potentially found a new supplier or taken steps to minimize the damage. But what if there's no clear market price for these robot action figures a month before the event?
Yeah.
What if they were a limited edition, one-time only production run?
That's where the flexibility of the UCC comes in handy.
Okay.
It allows for using what's called a reasonable substitute price from similar markets, adjusted for things like transportation costs. So we'd find something comparable, maybe a limited edition of another popular action figure,
Okay.
and we'd use that as a benchmark.
That's pretty clever. It sounds like the law tries its best to be fair and find a solution, even in these messy, unpredictable situations.
It does. It really does. It's like the law has this built-in sense of justice.
Yeah.
You know, like it's trying to right the wrongs even when things get complicated.
That's a great way to put it. But, even with these mechanisms in place, the non-breaching party still has a duty to mitigate their damages.
Right. Like in our robot action figure scenario,
Yeah.
I can't just sit back, relax, and expect to be compensated for the full potential profit I might have made at Comic-Con.
Right.
I still have to try to find another supplier or explore other options, even if it means paying a bit more or scrambling to find a solution. Exactly.
Yeah.
You can't just watch the ship sink, so to speak, when you have the opportunity to steer it to safety.
It's about being responsible and proactive even when you're the one who's been wronged. So, to bring it all back to our a la carte menu analogy, choosing the right remedy for a breach of contract is about understanding all the nuances.
Yeah.
We're looking at the type of contract, the specific promises made, the foreseeability of the damages, and the efforts made to mitigate those damages.
Absolutely. It's about crafting a solution that genuinely helps the injured party. And that depends on so many factors.
Right.
It's important to remember, though, the goal isn't to punish the breaching party.
Right.
It's about making the non-breaching party whole again.
It's like putting the pieces of a puzzle back together.
Yeah.
But sometimes we have to get creative to find the best fit.
What a great analogy. And just like with a puzzle, having all the pieces is essential. This is why clear, well-drafted contracts are so important.
Absolutely. It's all about setting clear expectations right from the get-go. Well, this has been an eye-opening deep dive. We've explored this a la carte menu of legal remedies for breach of contract, from the chef's special of expectation damages to the side dishes of reliance and consequential damages.
We even explored some real-life examples.
We did.
Like the Sullivan v. O'Connor case, which showed us just how messy things can get,
Oh, yeah.
even with seemingly straightforward agreements.
Absolutely. Understanding these legal options empowers you, our listener, to navigate the world of contracts with confidence. So whether you're drafting a contract, reviewing one, or, heaven forbid, dealing with a breach, knowing your rights and remedies is invaluable.
Knowledge, as they say, is power.
Now here's something to ponder as we wrap up this deep dive. In a world of increasingly complex contracts, how can we as individuals and as a society ensure greater clarity and understanding from the very beginning to potentially avoid these messy situations altogether? It's a question worth chewing on. Thanks for joining us for this deep dive, and we'll see you in the next one. Ever wondered what happens when a big business deal goes totally south? And I don't mean a mild disagreement. I'm talking full-on breach of contract where someone's potentially out big money.
Yeah, it's a bit like playing a high-stakes game of chess. Each side has these legal moves they can make to protect themselves.
Oh, I like that analogy. And we love to get into the nitty-gritty here on the show. So today we're doing a deep dive into contract remedies, our guide, the rulebook for business transactions, the Uniform Commercial Code, better known as the UCC.
Yeah, the UCC. It's important to remember that contracts, they're legally binding agreements.
Yeah.
And the UCC, it provides a framework for resolving disputes when those agreements fall apart.
Okay, so let's set the scene. Imagine you're a business owner, right? And you've just shipped this massive order, we're talking truckloads, of custom-designed T-shirts for a music festival. You've done your part, everything's on track, and then, bam, disaster strikes. The festival organizers, they call you last minute, and they're like, nope, sorry, we're pulling out, the deal's off.
Oh, man. That's a nightmare scenario for any business owner. But the good news is, the UCC, it offers some protection. Section 2703, it lays out a bunch of options that a seller can consider when they're hit with a buyer's breach.
Okay, options. Tell me more. I'm picturing a legal playbook here with different strategies depending on the situation.
Exactly. And sometimes the first option is the most obvious. You can just, stop the delivery. If those T-shirts are still in transit, you have every right to tell those trucks to turn around.
Right. Makes sense. Why let them get their hands on goods they're not going to pay for? But what if it's, too late for that? What if the shirts are already there, sitting in a warehouse at the festival grounds, just, under the organizer's name?
That's where you might consider stop delivery by a bailee. Basically, even if the goods have been handed off to a third-party shipper, you can tell that third party to hang on to them until the whole dispute is sorted out.
So the T-shirts are in limbo, stuck between the two parties. It seems like knowing where the goods are physically is super important here.
Oh, absolutely. Logistics, they play a huge role. Now, obviously, having thousands of T-shirts in storage indefinitely, it isn't ideal.
Yeah.
So the UCC gives you another option, reselling the goods. You can find a new buyer, even if you have to sell at a bit of a loss, and then go after the original buyer for the difference in price.
Right, so you're at least mitigating your losses, which is probably a smart move for any business owner. It's kind of like trying to sell your concert tickets last minute when your date bails. You might not get face value, but hey, something's better than nothing, right?
Exactly. And then, of course, there's always the option of, going after what you're owed, what we call recovering damages. The UCC allows you to sue the other party, the one who breached the contract, for the profit that you lost because they didn't hold up their end of the bargain.
Right, so you've got options to try and financially salvage the situation.
Yeah.
But are there ever times when, a business owner might just want to walk away from the deal completely?
Oh, absolutely. In some cases, the UCC allows for a complete cancellation of the contract. So that means the deal is off, both sides go their separate ways, and it's like the agreement never even existed in the first place.
So it sounds like the UCC, it really gives businesses some key safeguards, especially when you think about how much money can be on the line if a deal goes bad.
Oh, absolutely. And it's important to remember that these remedies, they're not just for big corporations with fancy legal teams, right? They apply to businesses of all sizes.
Right, because even a small contract issue can really snowball, especially for a newer business that's just starting out.
Exactly. Now, we've talked about what happens when the seller gets left hanging, but what about the other side of the coin? What can the buyer do when it's the seller who's breaking the contract?
Okay, yeah, let's flip the script. So going back to our music festival, right? This time, you're the festival organizer. You've booked all the bands, the tickets are sold, the big weekend is right around the corner. And then you get this call saying, the stage you ordered, the one your headliner absolutely needs, is not coming. Disaster.
Total disaster. And that's exactly why the UCC has remedies for buyers, too. You'll find those in Section 2711. And in a situation like this, one of the first things a buyer might want to consider is cover.
Cover. Okay, so is that like basically finding a replacement for the stage?
Yeah, precisely. It's about minimizing the damage that the seller's breach caused.
Yeah.
You'd immediately start looking for another stage to rent, even if you have to pay a premium because you're in a time crunch.
Right, because, I mean, the show must go on, right? But that doesn't mean the original seller is off the hook, does it?
Nope, not at all. The UCC, it lets you recover the difference in cost between that original stage and the replacement. Plus, any other, reasonable expenses that piled up because of the seller's mess up. Like, imagine you had to pay for expedited shipping or some kind of rush delivery fees. You could tack that on.
Okay, so you're not just eating the extra cost because of their mistake, which makes sense.
Exactly. It's about getting the buyer back to where they should have been if the seller, done what they were supposed to do in the first place.
Now, finding a replacement stage last minute, that already sounds crazy stressful, but I'm guessing it's not always even possible. So what if, in this scenario, there are just, 0 other stages to be found? Then what?
Well, that's where things get even more interesting because the UCC, it also has something called damages for non-delivery. Basically, you can sue the seller for the difference between what your original contract said, that price you agreed on, and what the current market price for the stage is now.
Ooh, okay, so, if the cost of renting a stage has, gone way up since you signed that original contract, the seller could end up owing a lot of money.
Exactly. And this part, it's especially important when, the market for certain goods is really unpredictable. Prices are all over the place.
Yeah, that really shows how, timing is everything when it comes to these
It
contracts.
really is. Now, everything we've talked about so far, it's all been about remedies that mainly involve money, right? But what happens when the thing in the contract, it's something totally unique, something you can't just replace with money?
Okay, now I'm really intrigued. Let's say instead of a stage, it's this super rare vintage guitar. You tracked it down specifically for your headlining musician to play. It's one of a kind, and now the seller's trying to back out of the deal.
That's when you get in this area called specific performance. It's a powerful legal tool, but courts usually only use it when you're dealing with something unique, irreplaceable. It basically means a court can, order the seller to hand over those goods just like they promised, even if they've gotten a better offer from someone else.
Wow, so it's like a legal order saying, nope, you made a deal, now you got to stick to it, even if it's a pain.
Exactly. And this remedy is especially important in those cases where just getting money, it wouldn't really make things right for the buyer.
You're right, because how do you even put a price tag on something that's truly irreplaceable?
Exactly. Exactly. Now, it's important to remember the UCC gives us the rules of the game, right? But real-life legal cases, they can get messy. There are always these little details or weird situations that can change how these remedies actually play out.
So knowing the basics is good, but talking to a real lawyer, that's always a smart move when you're dealing with this stuff.
Oh, absolutely, 100%.
Yeah.
Now, you mentioned earlier how timing can be everything in these contract disputes. And there's actually this fascinating legal case that shows this perfectly. NIPSGAO v. Carbon County Coal.
Ooh, a real-life legal drama. Tell me more.
So you had NIPSGAO, this power company. They had a long-term contract with Carbon County Coal to buy coal at a certain price. Sounds
Yeah.
simple enough, right? But then, the energy crisis hits, and suddenly the market price for coal, it, explodes.
Oh, I bet Carbon County Coal was having some serious second thoughts about that deal.
You bet they were. They wanted out of that contract, saying it was unfair that they were losing a ton of money selling their coal so cheap. They even claimed that sticking to the deal would bankrupt them.
So they basically wanted to break the contract, sell their coal for way more in the open market. Can't say I blame them for trying.
Right. It shows how, stuff that's totally outside anyone's control can change the whole game. But here's where it gets interesting. The court, they actually sided with NIPSK.
They did. Wow. Okay, I did not see that coming. So even though things had changed so drastically, the court still made them honor the original contract.
Yep. And the reason why is actually pretty interesting. The court, they said that just giving NIPSQ money, it wouldn't truly fix the problem. See, NIPSCO, they needed that coal at that specific price to keep their power plants running, to literally keep the lights on for people. Letting Carbon County Coal break the contract, it would have this ripple effect, maybe even causing energy shortages. People would have been seriously hurt.
So it became about way more than just dollars and cents. It became about keeping a promise that had a huge impact on a lot of people.
Exactly. It shows how courts, They often have to look at the bigger picture, think about the consequences, not just the legal technicalities. When they're making decisions about these contract remedies, it's not always black and white.
That's a good reminder. I mean, we're going over this stuff in a, somewhat simple way, but the reality is contract law can be super complex.
Oh, it can be a jungle out there. Now, besides specific performance, which we talked about, there are other remedies that go beyond just, writing a check.
Oh, like what? Give me an example.
Okay, imagine this. Someone's not only breaking the contract, but they're actually doing damage in the process. Like, let's say you find out an old employee, someone who signed a non-compete, is trying to steal your clients, like actively sabotage your business.
Ugh, okay, yeah, that's every business owner's nightmare. What can you even do in that situation?
That's where an injunction comes in. It's basically a court order that says, stop, you can't do that anymore.
So with the employee example, the court could tell them to stop contacting your clients, stop trying to steal your, trade secrets.
Exactly. It's a way to, stop the bleeding while the larger contract issue is getting sorted out.
Okay, so it's like a legal cease and desist.
Exactly. It gives you some immediate protection when, just money wouldn't really solve the problem.
And it sounds like injunctions, those could be used in all sorts of situations, right? Yeah.
Oh, yeah, definitely. You see them a lot in cases about intellectual property, unfair competition, sometimes even defamation.
So another good tool to have in your back pocket, legally speaking.
Absolutely. All right, so we've covered a lot here. We've talked about what sellers can do when a contract's broken, what buyers can do, all sorts of remedies. But there's one more I want to touch on, kind of like a last resort.
Okay, lay it on me. What is it?
It's called rescission. Think of it like hitting the undo button on the entire contract.
So, with that vintage guitar, if the deal went completely south, the seller was being totally unreasonable, the court could say, nope, give the guitar back, the buyer gets their money back, we're acting like this whole thing never happened.
Exactly. It's like wiping the slate clean. Both sides, they go back to the exact position they were in before they even made the agreement.
So, a total do-over. When would a court actually do that?
Rescission, it's usually only for situations where the breach is super major, so bad, it basically destroys the whole point of having the contract.
So if there was fraud involved, or maybe one person lied about themselves or the product or service they were offering.
Yep, exactly. Or let's say the contract was signed because of a mistake,
Huh.
or maybe someone was pressured into it. It's basically the court saying, this agreement is so messed up, there's no fixing it, let's just go back to square one.
Okay, yeah, that makes sense. It's like a legal reset button.
Exactly. But even though it seems like a clean break, rescission doesn't always mean you completely erase what happened under the contract. Sometimes there's this thing called restitution that has to happen too.
Restitution. All right, break that down for me.
So even if the contract is, officially undone, the parties might still have to give back any benefits they got from the deal.
So, if someone had already made a down payment or something, they'd have to be paid back.
Exactly. Or if they already exchanged goods, they'd have to be returned.
So even though you're basically hitting undo, there's still this idea of fairness.
Exactly. It's not about punishing anyone. It's about trying to recreate the situation that existed before the contract ever happened.
That makes sense. Now, earlier, you mentioned a case about specific performance, how it comes into play with these unique items. Can you tell me a bit more about that one?
Oh, yeah, absolutely. That was Curtis Brothers Covey Cats. And it involves, wait for it, tomatoes.
Tomatoes. Okay, now I have to hear this. What's the story with Curtis Brothers v. Cats?
So Curtis Brothers, they were this tomato canning factory, right? And they had this contract with a farmer, Mr. Katz, to buy his entire tomato crop. Pretty standard business deal, you'd think.
Yeah, sounds simple enough. What could possibly go wrong with tomatoes?
Well, as it gets closer to harvest time, Mr. Katz is having second thoughts. Turns out, the market price for tomatoes has shot way up, and he realizes he could make a lot more money if he sold them somewhere else.
Classic case of seller's remorse.
You got it. So Mr. Katz, he decides to break his promise, breach the contract with Curtis Brothers so he can sell to the highest bidder.
I'm guessing Curtis Brothers was not happy about this.
Not at all. You see, they were counting on that specific crop of tomatoes from Mr. Katz to keep their factory running, to fulfill their own promises to other businesses. They couldn't just use any tomatoes. They needed his tomatoes.
Oh, I see where this is going. It's not just a simple business deal anymore.
Nope. For Curtis Brothers, it was make or break time. They needed those tomatoes to survive. So they took Mr. Katz to court, and they asked for specific performance.
What did the court say? Did they side with the tomato factory?
They did. The court said, look, just giving Curtis Brothers money wouldn't really cut it. They needed those tomatoes, and money couldn't magically make them appear. So the court ordered Mr. Katz, you will hand over those tomatoes, as you promised.
Wow, so the court actually forced him to do what he said he'd do. That's kind of amazing. And it really drives home the point that specific performance, it's powerful, especially for these unique goods. But I'm guessing it's not something courts do very often, right?
You're right, it's pretty rare. They only use it when money wouldn't be enough to fix the problem. And it's really up to the judge to decide if it's the right move for the situation.
So it's not like a guaranteed win if you go to court, but it's at least an option in certain cases.
Exactly. And this whole case, it just goes to show contract law is full of surprises. I mean, who knew something as ordinary as a tomato could cause such a dramatic legal battle?
Right. It's a good reminder that contracts, they're everywhere, and they matter a lot. And it's pretty cool how the law has come up with ways to deal with even the weirdest, toughest contract disputes.
Couldn't agree more. Just understand the basics of contract law and what you can do if things go wrong, it can really make a difference, whether we're talking about your work life or your personal life.
Absolutely. And it feels like we could do a whole other deep dive on real-life cases like
Oh,
these.
for sure. There's no shortage of fascinating legal battles out there.
Well, on that note, we'll have to save those cases for another time. We've been through a lot today, from stopping delivery trucks to the case of the missing tomatoes.
A whirlwind tour of contract remedies.
It really has been. I think our listeners are going to walk away knowing a lot more about what they can do if they ever end up on either side of a breach of contract.
I hope so.
But hopefully, after listening to all of this, everyone's going to be extra careful when they're putting those agreements together. Try to avoid those legal headaches in the first place.
Absolutely. A well-written contract, it's the best way to prevent problems from happening in the first place.
Couldn't agree more. All right, listeners, if you're ever not sure about something in a contract, please go talk to a legal professional. It is always, always better to be safe than sorry. It sounds like knowing even a little bit about this stuff can really, protect you, whether you're running a big company or just starting out.
Oh, for sure. Like they say, knowledge is power, right? And that's especially true with contracts, because they can be tricky.
Totally agree. So listeners, next time you're about to sign on that dotted line, whether it's for like 1,000 t-shirts or something way more unusual, remember what we talked about today. All those clauses and legal terms, they're not just there to confuse you, they're actually there to protect you if things go sideways.
And even though we've covered a lot today, contract law, it's a huge topic, always changing. So if you're ever unsure about your rights, what you're agreeing to, definitely talk to a legal professional. They can give you advice that's specific to your situation, help you make sense of it all.
That's great advice. Sometimes you just need that expert in your corner. Well, folks, that brings us to the end of another deep dive. We've been exploring the wild world of contract remedies, all the legal tools and tactics that buyers and sellers can use to protect themselves.
We talked about everything from, like, literally stopping those delivery trucks to making sure those tomatoes get delivered. And we learned that contract law, it could be pretty nuanced. Sometimes you really do need a lawyer's help to make sense of it. But I think the big takeaway is having a well-written contract in the first place, that's your best bet to avoid problems down the road.
Absolutely. So listeners, we hope you've learned a lot today, that you feel more confident about dealing with contracts. And until next time, happy contracting, everyone. All right, let's talk money. Specifically, the kind that says, you broke your promise, so now you owe me. We're doing a deep dive into compensatory damages in contract law. Because, let's face it, sometimes a handshake just isn't enough.
Especially when those hands are covered in chocolate. From what I see here, it seems like you're prepping for a situation maybe where a contract might be broken. And you want to know how courts decide what someone has to pay to make things right.
Exactly. We're talking serious legal research here, notes on cases, statutes, the whole shebang. So no more of these law school hypotheticals, We're getting down to brass tacks.
And what's so fascinating is it's not about, like, punishing the person who messed up. It's about restoring that balance. You can almost imagine, like, a scale. A breach, it tips the scale. And those compensatory damages, they're the weights that kind of bring it back to level.
I love that analogy, the scale. Okay, so no making them pay just out of spite. It's about making the injured party, whole again. But how do you actually put a price tag on that wholeness?
Well, that's where things get really, really interesting. And as you've probably seen in your research, it can get surprisingly complex. The burden of proof, it lies heavily on the injured party. They can't just, walk into court and demand $1 million because sent them the wrong lunch order. They need to prove with, what's called reasonable certainty that the breach directly caused a very specific amount of loss.
So reasonable certainty, meaning you can't just throw out like random numbers. It's about backing up your claim with like solid evidence, right?
Exactly. And a great example of this is the case of Glendale Federal Bank. They learned the hard way that even when you're dealing with a government breaking a promise, you need really, really rock-solid proof to get compensated.
Okay, so evidence is king, but like once you have that evidence, how do courts actually calculate these damages? I'm guessing it's not like a one-size-fits-all situation.
You're absolutely right. There are 3 main approaches, each with a distinct flavor, you can say. We have expectation damages, reliance damages, and restitution damages. Let's start with maybe the most common type, expectation damages. These aim to give the injured party the benefit of the bargain, as they say. So it's really about putting a price tag on that unmet expectation.
Okay, so using a hypothetical from my notes here. Let's say I order a custom-built, life-size replica of my childhood home, made entirely of chocolate. But the contractor shows up with a gingerbread house instead. Now, expectation damages in this case, they're about more than just, like, the cost of the ingredients, right?
Absolutely. It's about that difference in value between that chocolate masterpiece that you were expecting and that gingerbread house that you actually received. Think of it as compensation for your shattered chocolate dreams.
No, that is what I call a delicious legal concept. Okay, so what about reliance damages? When would those come into play?
When those expectation damages, they get a little too fuzzy to actually calculate. Say, you're trying to put a price on like the emotional distress of having your dreams of a chocolate house betrayed. It's more about making you whole for those investments you made, relying on the contract actually being fulfilled.
Like if I hired a whole marching band to like parade around my edible mansion, I could try to claim those costs, even though the house itself, it's a no-show.
Exactly. And the American Mechanical Corps v. Union Machine case, that really highlights how courts sort of grapple with this. American Mechanical, they were facing financial trouble. They agreed to sell their property to Union Machine, but then Union Machine actually backed out of the deal. And because of that breach, American Mechanical's bank, they ended up seizing the property and then selling it for much less, at a foreclosure sale.
So American Mechanical sued for the difference in price, right? It seems like a pretty clear case of them losing money because, Union Machine backed out.
They did. But Union Machine, you see, they argued that American Mechanical, that they should have done more to reduce their losses. It's what's known as mitigation of damages. However, the court ultimately actually sided with American Mechanical. They found that Union Machine, well, they should have foreseen those consequences of their actions.
So even if you're in the right, you can't just like sit back and let those losses pile up, right? You have to try to minimize the damage, be proactive about it. That's a good takeaway.
Absolutely. Now let's move on to another case. This one also falls under expectation damages. But this time it really focuses on the difference between what we call a trivial breach and a material breach. We're talking American Standard v. Schechtman.
Okay, a material breach, that sounds serious. Like the foundation of the contract, it's shaken. What was the issue in this case?
So in this case, we have American Standard. They hired a demolition contractor, a company called Schechtman, to clear out this plant that they were, shutting down. Schechtman, they did most of the work. They demolished the buildings, removed the equipment, all that. But they didn't fully level the property, as had been agreed upon in the contract.
And they tried to argue that that was just a trivial breach. It seems like, a key part of demolition is making sure that the land is ready for whatever is coming next. Right?
Exactly. American Standard, they wanted, the cost of actually completing that grading work. They argued it was a material breach. But Schechtman, well, they claimed that their breach was trivial. Because even though the land wasn't perfectly level, American Standard could still technically sell the property.
So they were basically saying, like, it's fine, you can still sell it, but something tells me the court, they weren't really buying it.
They weren't. The court actually sided with American Standard. They said, that grading work, that was a key part of the contract. And Schechtman's failure to complete it, well, that was a material breach, not a trivial one. And they emphasized, the court did, that Schechtman had acted willfully in not completing that part of the contract, meaning that they made a conscious choice not to do it.
So it was less, oops, we forgot about that, and more like, we don't want to do that. And it seems like the court really wanted to emphasize that a contract is a contract, right? You can't just pick and choose which parts you want to fulfill.
Absolutely. And, this case, it also touches upon this concept of what we call the economic waste doctrine, which we'll delve into a little.
Ooh, a little bit of legal foreshadowing. I like it. Okay, so we've seen how those expectation damages can play out in a couple of different scenarios now. What about our third flavor, restitution damages? Those are all about like preventing what we call unjust enrichment.
Right, precisely. Let's look at the case of Bernstein v. Niemeyer. This one really helps illustrate this concept. It revolved around a real estate partnership that, well, it went pretty sour. The Bernstein brothers, they invested heavily in this partnership. They were encouraged by a guy named Niemeyer. He essentially guaranteed those loans. But then the real estate market crashed, the lender defaulted, and the Bernsteins, well, they lost almost everything.
Ouch. That's rough. So they went after Niemeyer to try to get their money back.
They did. They were seeking what's called restitution.
Mhm.
They felt that Niemeyer had benefited unjustly from their investment.
Yeah.
But Niemeyer, his argument was that he had lost a significant amount of money, too. Even more, he claimed, than the Bernsteins.
So it was a case of everyone claiming to be like the bigger victim. What did the court say?
In the end, the court actually sided with Niemeyer. They found that he hadn't actually benefited from the situation because he was out even more money than the Bernsteins. And it really highlighted that restitution isn't just about simply making one party whole. It's about fairness and making sure no one profits unfairly from the situation.
Okay, that makes sense. So even though Niemeyer, maybe he played a role in the brothers' decision to invest, the court didn't find what you called that unjust enrichment. But let's say Niemeyer had walked away with the profit while Bernstein's lost everything. Would that have changed things?
Potentially, yes.
Yeah.
Because you see, that's really the crux of restitution. It's about preventing one party from gaining at the direct expense of another. Now, let's move on to another case. This one also demonstrates restitution, but from a bit of a different angle.
Hit me with it.
Okay, so this one is Britton v. Taylor. This case is about an employee who quit before his one-year contract was up. And get this, the employer refused to pay him anything. Their argument was he hadn't held up his end of the bargain.
Harsh. Did the court agree with that?
They did not. In fact, this Britton v. Taylor case, it's actually a landmark decision when it comes to restitution. The court, they invoked the concept of quantum meruit, meaning as much as he deserved.
Mm-hmm.
They argue that even though the employee hadn't finished out the entire year, the employer still received a benefit from the work that he did do.
So it was about preventing the employer from essentially getting away with free labor.
Exactly. They awarded the employee payment for the work he had done. But it's important to note, it wasn't based on that full contract price. It was calculated based on the market value of those services that he had actually provided.
That seems like a fair compromise. It recognizes the value of the work that was actually done while also acknowledging that, the full contract wasn't completely fulfilled. So we've covered 2 out of our 3 main types of damages here, expectation and restitution. Now, what about reliance damages? You mentioned earlier that the American Mechanical case, it highlighted how courts handle those reliance damages, but it also seemed connected to this idea of mitigation of damages. Can you walk me through how those 2 concepts kind of intertwine?
You're right, to connect those 2 ideas. Reliance damages and mitigation of damages, they often go kind of hand in hand. Remember, with reliance damages, you're trying to be compensated for those expenses that you made, because you relied on that contract actually being followed. But courts, well, they also expect you to take reasonable steps to minimize your losses, right? That mitigation part of it.
So it's not enough to just sit back and say, well, they broke the contract, so now they owe me for everything. Yeah. You have to actually show that you were proactive.
Exactly. Going back to that American Mechanical case, they couldn't just expect to be paid, that full contract price after Union Machine backed out of the deal. They had to actually demonstrate that foreclosure sale, which resulted in that much lower price, that was a reasonable attempt to mitigate their damages.
So even though it wasn't really their fault that the deal fell through, they still had a responsibility to kind of make the best of a bad situation.
Precisely.
Yeah.
And, this idea of mitigating your damages, well, it applies to, all different kinds of contract breaches. It really underscores the court's focus on fairness and, finding a just outcome for everyone involved.
That makes sense. Now, shifting gears a bit here, you mentioned earlier that the American Standard case, that's the one where the demolition contractor didn't finish grading the property.
Yeah.
You said that this case also touched upon this idea of the economic waste doctrine. We briefly alluded to it before. But what exactly is the economic waste doctrine? And, how does it impact the calculation of damages?
It's a fascinating concept. It adds, another layer of complexity to these cases,
Yeah.
especially when you're dealing with expectation damages. Remember, those expectation damages are all about putting the injured party in the position that they would have been in. If that contract had been fully performed, no breach.
Right. So, if you ordered that chocolate house and you got a gingerbread house instead, it's about like making up that difference in value, not just, giving you back the money that you spent on the chocolate.
Precisely. But sometimes, strictly enforcing that, what they call benefit of the bargain, well, it could lead to what the courts consider economic waste. This usually comes up in situations where, you know, fixing the breach, it would be incredibly costly, and it wouldn't actually add much value to that final result.
So, like, tearing down a perfectly functional building, just to use like a slightly different shade of paint, that would be economic waste.
Exactly. A classic example of this is actually the case of Peavy House v. Garland Coal and Mining Co. In this case, you had the Peavy houses. They leased part of their farm to Garland Coal for strip mining. As part of that lease, Garland Coal promised to restore the land, back to its original condition after they finished mining.
Seems pretty straightforward. You use the land, you clean up after yourself. What went wrong?
Well, Garland Coal, they didn't exactly hold up their end of the bargain. They finished their mining operations, but they left the land in a, shall we say, less than ideal state. The Peavy houses, they sued. They demanded that Garland Coal pay for the full cost of restoring that land back to how it was, like they promised.
Seems reasonable. A deal's a deal. What did Garland Coal argue?
Garland Coal argued that the cost of, fully restoring the land, it would be astronomical, way higher than, the actual decrease in the property's market value because of, their failure to restore it.
Yeah.
They basically claimed that it would be a colossal waste of money to make them fully restore that land, when the impact on the actual property value was relatively small.
So they were basically like pleading with the court to be practical about it. Did the court agree?
They did. This case is a perfect illustration of how courts, are sometimes willing to deviate from that traditional, what we call the cost of completion approach, especially when it would lead to a really nonsensical outcome.
So even though the Peavy houses, they didn't get their land fully restored like they were promised, the court decided that awarding them the full restoration cost, it would be like throwing good money after bad.
Precisely. The court took that economic waste doctrine into account, and they awarded the Peavy houses a much, much smaller amount, reflecting the actual difference in the property value.
It sounds like the court basically said, yes, there was a breach here, but let's not get carried away.
Exactly. The economic waste doctrine, it's all about finding a balance, you see, holding parties accountable for those breaches, while also making sure that the remedies imposed by the court, they're reasonable, and they make sense, in the grand scheme of things.
Now, this whole discussion about, economic waste and whether something is like trivial versus material, it seems a bit, I don't know, subjective. Is there like a magical formula for deciding when this economic waste doctrine actually applies?
Unfortunately, no. And that's part of what makes contract law so fascinating and, challenging. It often really comes down to the court's interpretation of the specific facts of that particular case.
So having a skilled lawyer in your corner, someone who can really argue your side effectively, that's probably a good idea.
Absolutely. And speaking of cases that really hinge on this distinction between material and trivial breaches, the case of Jacobs and Youngs v. Kent, that's a must-know. It perfectly illustrates how this concept, this material versus trivial, can really impact the application of that economic waste doctrine that we've been discussing.
Okay, give me the rundown on Jacobs and Youngs v. Kent. What happened in that case?
So in this case, we have a construction company, Jacobs and Youngs. They agreed to build a house for this guy, Mr. Kent. Seems pretty straightforward, right?
So far, so good. I'm assuming something went wrong.
Oh, it wouldn't be a contract law case without, a few hiccups along the way. The contract in this case, it specified that all of the plumbing pipes, they had to be of a very specific brand, reading pipe.
Sounds like Mr. Kent was particular about his plumbing.
You could say that. Well, it turned out that Jacobs and Youngs, for whatever reason, they used a different brand of pipe for some of the plumbing. The catch, this other brand, it was practically identical to Reading pipe in terms of, quality and functionality.
So essentially the same, just like a different name on the label. Did Mr. Kent know about this substitution?
He did not, at least not until the house was almost completely finished. When he found out, well, let's just say he was not happy. He demanded that Jacobs and Young's, that they rip out all that plumbing and replace all the non-redding pipe with the correct brand. The problem, doing so, it would require them to tear down the walls and basically rebuild parts of the house.
Yikes. Talk about a costly mistake. Did Jacobs and Young's actually agree to do that?
They did not. They argued that that pipe substitution, it was a really minor, insignificant deviation from the contract, what we call a trivial breach, as opposed to a material one. They said it requiring them to tear down those walls and replace perfectly good pipes. Well, they said that would be absurdly expensive and that it wouldn't actually provide any real benefit to Mr. Kent.
So they were basically saying, yes, we messed up, but it's not that big of a deal.
Exactly. And this, you see, this is where that economic waste doctrine that we talked about earlier, that's where it really takes center stage again. The court had to decide, was this pipe substitution a material breach that, went to the heart of the agreement? Or was it just a trivial oversight, that didn't really have a significant impact on the value of the house itself?
So what did they decide? Was Mr. Kent within his rights to demand that those pipes be replaced, even if it meant, this major construction project to rip out those walls and everything?
Well, in the end, the court actually sided with Jacobs and Young's, the construction company. They found that the pipe substitution, while technically a breach of contract, yes, it was a trivial breach, they really emphasized that those pipes, they were essentially the same. No difference in quality, durability, appearance.
So Mr. Kent's, his insistence on having that redding pipe, it kind of backfired on him.
You could say that. The court, they ruled that it would be what they call economic waste, to force Jacobs and Young's to tear down those walls and replace those perfectly functional pipes. They awarded Mr. Kent what we call nominal damages. Essentially, it's a way of recognizing that there was a breach, but also acknowledging that it didn't really harm him in any meaningful way.
I bet Mr. Kent was not too happy about that. So this case really shows how important it is to distinguish between, like, those material breaches, the ones that really strike at, like, the core of the agreement, versus those trivial breaches, which are more like, technicalities.
Exactly. And it also highlights how that economic waste doctrine, it can really protect parties from having to pay for remedies that are completely out of proportion to the actual harm that was caused.
It seems like this whole idea of substantial performance is also kind of at play here. Even though Jacobs and Young's, they didn't perfectly fulfill every single tiny detail of that contract. They essentially provided Mr. Kent with, what he bargained for, a well-built house.
You're absolutely right. The concept of substantial performance, it often goes hand in hand with that economic waste doctrine. If a court finds that a party has substantially performed, meaning they've done, most of what they promised, even if there are some, minor deviations, they're less likely to demand strict compliance with, every single tiny detail.
Especially if enforcing those tiny details would be, like, ridiculously expensive or impractical.
Precisely. It all comes back to finding that balance between, holding parties accountable for the agreements they make and also ensuring that the remedies that are imposed, they're fair, they're practical, and they don't create more problems than they solve.
This whole discussion has been incredibly illuminating, but it also makes me realize, like, how important it is to have a really well-drafted contract in the first place.
I couldn't agree more. A clear and precise contract, it can prevent a lot of these headaches down the road. Vague language, ambiguous terms, those can be, a recipe for disaster.
It's like they say, an ounce of prevention is worth a pound of cure. Knowing what we know now, I'm guessing that, like, the contract in that Jacobs and Young's v. Kent case, it could have been more specific, about the consequences of using a different brand of pipe.
You're absolutely right. Had that contract explicitly stated that, any deviation from that specific brand, redding pipe, that it would be considered a material breach, regardless of, the quality of the substitute, well, the outcome might have been very, very different.
It seems like these cases, they really underscore the importance of, thinking through all the possibilities, being as detailed as possible in that contract. And maybe even, consulting with a legal expert when you're actually drafting these things.
Precisely. Because once you sign on that dotted line, you're bound by those terms. And the courts, they're going to look to that document to interpret your obligations and to determine what the appropriate remedies are if things go wrong.
So for our listener out there, who's gearing up for a situation where a contract might be breached, what's like the biggest takeaway from all of this?
Well, I think the biggest takeaway for me is like clarity is key. Knowing these different types of damages, how they're calculated, the evidence that you need, it arms you to negotiate like fairer contracts right from the get-go.
Absolutely. It's like having, X-ray vision into the legal system. You're understanding the potential consequences of a breach for both sides, not just the injured party.
Right. Like even if you're technically in the right,
Yeah.
going after someone for like every penny when it would be like economically absurd, the court, they might not be so sympathetic to your case.
Exactly. And this whole discussion, it really highlights how contract law, it's ultimately about more than just those words on a page. It's about, understanding the intent behind those words, the expectations of the parties that are actually involved, and the real world impact of, those broken promises, which is where having that solid evidence really comes in. You need to be able to prove not just that the breach happened, but the actual harm that it caused.
Precisely. Vague claims, speculative losses, those just won't cut it in court. Remember the Glendale Federal Bank case.
Yeah.
Even when you're dealing with, a breach by the government, you still need like rock solid proof to actually back up your claim.
It's all starting to like click together now. The types of damages, the evidence, that economic waste doctrine, even that idea of like substantial performance. It's like a giant legal puzzle where all the pieces are kind of connected.
That's a great way to put it. And, by understanding how those pieces all fit together, well, you can navigate the complexities of contract law with more confidence and really, make those informed decisions that protect your interests.
Well said. And speaking of protecting your interests, I think another major takeaway for our listener here is the importance of, seeking out that expert legal advice.
Absolutely. Whether you're, drafting a contract, maybe you're facing a potential breach, or even, if you're trying to enforce your rights under a contract that's already been broken, having a skilled attorney in your corner, it can make all the difference.
Right. Because as much as we've learned from this deep dive, I'm also realizing there's a whole lot more to contract law than we could ever cover, in one sitting.
That's the beauty of it, though, isn't it? It's a constantly evolving field with, endless nuances and complexities. Every case, it presents its own unique set of facts and challenges, and that's what keeps it so intellectually stimulating.
I'm definitely feeling more stimulated, that's for sure. But on a more serious note, I think this deep dive, it's given our listener, a solid foundation for understanding these compensatory damages and how they actually play out in the real world.
I completely agree. They're now armed with the knowledge,
Yeah.
To ask the right questions, to really assess their options, and to navigate these situations with, more awareness and more confidence.
And with that, well, we'll wrap up this deep dive into the fascinating world, I would say, of compensatory damages. Hopefully you found it as enlightening as I did. Remember, knowledge is power, especially when it comes to understanding your rights and navigating that often complex world of contracts. Until next time.
Welcome back, listeners. Ready to dive deep into some more juicy legal scenarios?
Yeah.
Today we're tackling a topic that's crucial for anyone who's ever glanced at a contract, and let's be honest, that's pretty much everyone.
You got it. We're talking contract law remedies, specifically that intriguing concept of divisible contracts. Sounds a bit technical, I know.
It does, but trust me, it's way more interesting than it sounds. Picture this. You've got this big, beautiful contract, right? Like a perfectly baked cake. And each part of that contract, that's a delicious slice. But what happens if someone only finishes half their slice? Do they still get paid for what they ate?
That's the million-dollar question, isn't it? And it all boils down to whether a court sees this whole cake as one big agreement or if they're willing to cut it up into smaller, independent mini-contracts.
So it's like, can we separate the wheat from the chaff, legally speaking?
Yeah.
And I see our source material mentions something called the Restatement Section 240. Sounds pretty official, right?
It is. Think of it as the rule book for figuring out if a contract can be divided. Basically, it says a contract's divisible if it's written that way up front, like you get paid X amount for completing Y task.
So far, so good. But I'm guessing it gets a tad more complicated than that.
Oh, you know it. There's this other scenario where even if the contract doesn't explicitly say it's divisible, a judge might still split up if they think one part not being done wouldn't totally wreck the whole deal.
It's all about those independent slices again, right? Each part having its own value. To really get this, let's look at that case with Marcus Slowey. The one with the street construction project that didn't go quite as planned.
Ah, yes, the Lowy case, a classic example of divisibility in action. Lowy's agreed to do this whole street construction project, but things went south before he could finish it all.
And didn't he actually manage to complete a huge chunk of the work before things went sideways?
He did. Like 98% of the project was done. Can you believe it?
98%. That's like almost the whole street. So did they really make him swallow the cost of that last little bit?
Not a chance. The court took a look and said, hold on here. Each part of this construction gig has its own value, and you built almost the whole thing. You deserve to be paid for what you accomplished.
The court basically saw through the mess and made sure he got his due, even though the entire project wasn't technically wrapped up with a bow.
That seems pretty fair. Now, I'm thinking about another scenario here, one with a slightly different outcome. What about that case with New Era Homes, the one where they had that whole installment payment plan for a home renovation? Wouldn't that automatically make it a divisible contract?
You'd think so, right? I mean, they had those payments all lined up for each stage of the renovation. But here's the thing, and this is where it gets really interesting. The court actually said, nope, those payments on their own didn't make it a divisible contract.
Wait, really? So even with those clear-cut installment payments, it still wasn't a done deal for divisibility. Why is that?
Well, in that particular case, the court sided with the homeowner, you see. They realized that the homeowner wasn't getting the whole package, that fully renovated home, until everything was finished. So even though they had those payments for each stage, the court looked at the bigger picture, the heart of the agreement, which was that complete home makeover. So it wasn't about those individual slices anymore. It was about the whole cake being, well, completely baked.
Exactly. It's a good lesson that just because a contract looks divisible at first glance, you got to dig a little deeper, look at the bigger picture, and see if it truly holds up.
It's like a reminder to always read the fine print and think about those what-ifs before you sign on the dotted line. Speaking of what-ifs, what happens when a contract goes completely haywire and a simple payout just isn't going to cut it? That's where things get really interesting with those equitable remedies. But we'll save those for another deep dive. Equitable remedies. It's like stepping into a legal wonderland where money isn't the only solution. What kinds of situations are we talking about here when we say money just doesn't cut it?
Imagine you finally found it, that vintage first edition of your favorite childhood book. You know, the one you thought was lost forever.
Oh, I get it. The one with sentimental value. Something money can't really replace.
Exactly. You've got the contract all set, you're about to hand over the cash, and then poof, the seller backs out.
No. Heartbreaking. So, what can you do? You can't just conjure up another one of those books.
That's where specific performance comes in. It's like a legal magic wand. The court basically says to the seller, nope, you promised this very specific thing, so you have to deliver. Money's not enough.
Wow, so no more hiding behind a stack of cash to get out of a deal. It's like the legal system is upholding the spirit of the promise, not just the letter of it. Do you have any juicy examples of this specific performance in action?
Oh, absolutely. Picture this. It's the early 1900s, and Curtis Brothers, a big-time tomato canning company, they've got a problem. They had this contract for a whole bunch of tomatoes, but the seller, they decided to back out.
Oh no, tomato trouble. What do? Those canning lines can't just sit there empty during tomato season?
Exactly. And this is where specific performance swoops in to save the day. The court took a look and said, these aren't just any tomatoes. They're essential for Curtis Brothers' entire business. Money won't solve this. They ordered the seller to hand over those tomatoes just as they promised.
Wow, the court really held their feet to the fire. But what about those situations where it's not about getting something specific, but rather stopping something from happening, like hitting the brakes on an ongoing breach? That's where injunctions come in, right?
You got it. Think of an injunction as a legal stop right there. It's like a referee blowing the whistle in a game.
So it's like a preventative measure, a way to protect someone from further harm while things get sorted out. Got any real-world examples of that in action?
Remember that case? Walgreens versus Sarah Creek property? It's a classic. Walgreens had this sweet deal. They were the only pharmacy allowed in this whole mall. Then, the landlord, they tried to rent a space to a competitor.
Oh no, that's not right. Talk about a breach of trust. What happened next?
Well, Walgreens, they weren't going to take it lying down. They went to court, and the court slapped an injunction on that landlord, basically saying, you can't just break your promise like that. It stopped the landlord from renting to a competitor, protecting Walgreens and their business.
It's like the legal system stepped in to maintain the balance of power. These equitable remedies are really fascinating. It's like the law recognizes that sometimes a simple payout just doesn't address the true harm caused by a broken contract. But let's shift gears for a moment and talk about the emotional side of things. We've been deep in the legal weeds here, but what about the emotional roller coaster that often comes with a broken contract? I mean, can someone sue for emotional distress because a contract went sour?
That's a really good question, and one that comes up a lot, actually. You're right. Contracts involve people, and people, well, we've got feelings. It's natural to feel angry or even betrayed when someone breaks a promise, especially if it was something important.
So when it comes to contracts and the emotional fallout, does the law just say, tough luck, stick to the facts? Or can those hurt feelings actually hold weight in court?
Well, it's a tricky one. You see, the law, it tends to see contracts through a more practical lens, focusing on those concrete economic losses. But that doesn't mean emotional distress is completely irrelevant. There are some fascinating exceptions, situations where the court might say, okay, we see the emotional impact here and we're taking that into account.
Really? Okay, now you've got my attention. When do those exceptions usually pop up?
Think about it this way. Let's say it's your wedding day, one of the most emotionally charged days of your life, right? You've hired a professional photographer to capture all those once-in-a-lifetime moments. And then the unthinkable happens. The photographer completely botches the job.
Oh no, the wedding photo nightmare.
Yeah.
I can practically feel the heartbreak. But how does this tie into emotional distress and contract law?
Well, in this scenario, the emotional distress, it's not some distant possibility, it's practically a given. Those wedding photos, they're not just pictures, they're frozen memories. They hold immense sentimental value.
It's like their purpose, their very essence, is intertwined with
All
emotions. It
right.
wouldn't just be a financial loss, it would be an emotional blow as well.
Exactly. And because of that, because the contract was directly tied to something so deeply personal, the court might be more likely to say, okay, we get it. Emotional distress is a real factor here, and we're going to consider that when determining damages.
So in those cases where the contract is inherently tied to emotional well-being, like those wedding photos or even therapy agreements, the court might be more willing to step in and acknowledge the emotional impact of a breach. Fascinating.
Yeah.
Now, we've got a couple of cases here that seem relevant to this emotional distress dilemma. First up is Kaplan v. Mayo Clinic. It's a medical case. We all know how stressful and emotional those can be. So what went down in that case?
Well, in that particular situation, you had a patient who was misdiagnosed, which is a pretty distressing experience in itself. And while the potential for emotional distress was certainly there, the court ultimately focused on the financial aspect of the case, the tangible economic losses that resulted from the misdiagnosis.
So even though it was a situation ripe with emotional weight, the court stuck to the more traditional view of contract damages, focusing on those concrete financial losses. It seems like there's this constant push and pull between the emotional realities of a situation and the legal framework that governs it.
You've hit the nail on the head. It's a delicate balance. Now, speaking of balancing acts, sometimes a contract breach is so outrageous, so blatantly intentional, that it calls for more than just evening the score. It calls for a legal smackdown.
You're talking about those heavy hitter penalties, those punitive damages designed to teach someone a lesson they won't soon forget. When do those usually come into play?
You're right. We're not talking about everyday contract hiccups here. Punitive damages, they're reserved for those situations where someone acts with malicious intent. Think blatant fraud, deliberate deception, actions that go against the very grain of good faith and fair dealing.
Ah, so like that used car dealership case, Boise Dodge v. Clark, where they rolled back the odometer to inflate the car's value, that's just plain wrong.
Exactly. That's a prime example of when those punitive damages might come into play. The court recognized that this wasn't just a simple mistake, it was a calculated act of deception. They wanted to make sure Boise Dodge understood the severity of their actions, so they allowed for those extra penalties on top of the actual damages.
It's like the legal system sending a message loud and clear that this kind of behavior won't be tolerated. But let's shift gears for a moment and talk about a more proactive approach to handling those contract breaches. Can you actually spell out the consequences of a breach before it even happens, like write it directly into the contract itself?
Absolutely. In fact, it's a pretty common practice. It's called liquidated damages. And it's a way for the parties involved to say, okay, if one of us breaks this agreement, here's what happens. It's like having a backup plan built right into the contract.
So it's like a pre-negotiated settlement, avoiding a whole legal battle if things go south. What are some real-world examples of these liquidated damages?
Oh, they're everywhere. Think about those cell phone contracts we all know and love. Those early termination fees, those are a classic example of liquidated damages in action. You break your contract early, you pay a set fee. It's a way to create some predictability and avoid a lengthy court battle over the actual costs involved.
Ah, yes, those early termination fees. We've all been there. But haven't there been situations where those fees were challenged?
You're right, it's not a foolproof system. Courts have stepped in and said, hold on a minute, this liquidated damages clause, it can't just be a random punishment. It has to be a genuine attempt to estimate the actual damages caused by the breach.
So it has to be reasonable and grounded in reality, not just a way to penalize someone for breaking the agreement.
Exactly. It's all about finding that balance. And speaking of balance, let's talk about our final concept for today, the essential purpose rule. Think of it like a safety net built into the legal system. It recognizes that even with a well-crafted contract, things can still go wrong. And sometimes those predetermined solutions just don't cut it.
So it's like a legal override switch when things go truly haywire.
You could say that. The essential purpose rule basically says that even if a contract tries to limit remedies, perhaps through a liquidated damages clause, if those remedies fail to address the core issue, the court can step in and say, nope, we're going back to those default legal remedies to make things right.
It's like the legal system saying, we appreciate the effort, but we've got your back if things go sideways.
Exactly. A great example of this is the Lewis refrigeration case. There was this faulty freezer that just couldn't be fixed. And even though the contract tried to limit the remedies to a specific amount, the court said, hold on, that's not good enough. This freezer is a lemon, and the buyer deserves a more just remedy.
It sounds like the courts are pretty good at sniffing out those situations where a contract's predetermined solutions miss the mark. It's reassuring to know that there's a system in place to ensure fairness, even when things get messy. Well, there you have it, listeners. We've journeyed through the fascinating, sometimes frustrating, always intriguing world of contract law remedies.
We've seen how contracts try to anticipate problems and offer solutions, and how the legal system steps in to ensure those solutions are fair and just.
But remember, this has just been a crash course. Every contract dispute is unique, filled with its own twists and turns. So if you ever find yourself navigating the choppy waters of a contract dispute, it's always best to seek guidance from a legal expert who can provide personalized advice. Until next time, remember, knowledge is power, especially when it comes to contracts.